Yes, Borwa can it be 20 20.
Idea. Right.
One of
23.
yes 20 20. Huh?
20 lottery, PD not
23. Acha.
KJ not receive prisoner in interim. Yes.
You are on interim. They did not receive. It's remanded. Yes.
It is from
Gusam.
Kasa lordship. 8th of June.
8th of June. Interim be continued till next day. Item number 15. 15. Want to withdraw this one? Your good name is reflected here or S. Saikya? Pardon? Yes, I have heard Mr. S. Saikya, Dilane Council, and also heard Mr. P.P. Goswami, Dilane additional PPA, and it is submitted by Mr. Saikya that as per instructions of the petition, he wants to withdraw this. However, the scanned copy of this was already received by this court. Considering the submission made by Mr. Saikya, the matter is accordingly disposed upon it. Okay.
May I please, Lord? But with the consent of the other side, Lord, I have mentioned item number 45, Lord. Madam, I'm paying for adjournment, Lord.
You are otherwise you are for the petitioner or who?
Petitioner.
Yes. You have taken consent. You have taken consent of the you are the other side.
We have received a case diary here. Okay.
Oh, acha. With the consent of the other side, on counsel for the petition, 8.8. However, it is submitted by 45, no?
45.
However, it is submitted by by state by Mr. D.P. Goswami, the learned additional TP that CD has already been received. So, can you retain or
If 2 weeks, then we will send back the CD. Update.
if 2 weeks, then send back?
Send back.
Do not pass it. 2nd or 3rd of June. In that case, if you want 2 weeks, then we have to return back. No, sure. Or the prior in the month of May, there is very less possibility of giving you date. So let it be on 2nd of June, and we'll call for the case diary. 2nd of June, return the case diary, and call for an updated.
I did item number 28.
28.
Difficulties. On the other hand, probably report also 28. Without affair. It was called for, but the case diary was received. So case is registered against him. But earlier, Zalukbhai 137 of the 26. Petitioner Wahidur Rahman. 137 of the 26.
It is already
Case is registered and case diary also received. I'm one adjournment on the ground. I have gone through the FIR. The meantime, I will start.
No, CD we cannot give you to peruse, but can there be an FIR copy to be submitted or what otherwise? You are going to collect the FIR copy of the FIR?
Yes. So this weekend I will collect from the CR branch.
Okay then.
One adjournment next week.
The request made by the counsel for the petition, matter is item. However, it is submitted by Mr. Goswami, the SLPP. CD, the case has already been registered and CD is also received. In view of this, let the matter item. 25 কৰি দিব, interim be continued till next year. Item to I don't know. There is 19, 20, 21, and 22 are all connected.
All connected.
21 and 22. You are for 20, and who is for 19? Mr. Roy Chaudhary was all for 19. So, what is the position we have received? the case
CD
yet?
receipt.
So, you want to file an additional? Huh? 19, 20, 21, 22. Hard. Your MS? Hard MS NA Begum. The Learned Council appearing in AB 2977 of the 2020 paid for an adjournment, stating that they are going to file an additional affidavit in the matter. In that context, the Learned Council appearing for the AB 2978 and AB the 25 and AB 11 of the 2025 also raised no objection. Considering all the matters in the same series, let the matter be adjourned today. And how many weeks you need?
Lordship, we have some urgency in the case, Lordship. They are on interim, Lordship, and we need custody interrogation. So it may be as soon as possible, Lordship. CD is also here, Lordship. Only additional affidavit, Lordship, they can file it within 2 or 3 days.
So third one we cannot give, already CD is also here. File an additional, no issue. But next week we come up 22nd of 22nd of this month, and CD be retained till next year. Okay. Interim be continued till next year. All 4 items.
And Lordship, all 4 items be taken together, Lordship.
Yeah, all 4 items will be taken. That's why I have not heard the other
Yes,
items, because it may disclose something.
Lordship. We'll retain the CD, Lordship.
Sure.
Lordship. Chassis submitted, Lordship.
Chassis, sir.
Chassis submitted.
Yes. You are interim or no interim was there? There was an interim. Hard MS NA Begum, the Learned Council for the petition, also hard Mr. B. Sharma. And so, yes, what is the CS number?
27/26, dated 29/4/26.
Okay, we'll extending your interim up to 15 days so that you can appear. Okay. 40.
Hearing.
At the request made by Learned Council for the petition. At rate adjourned, is the 2014 matter. Date you want, any date fixed date here? 4th of June. Would be able.
Item number 38.
38. Item number 38.
38.
Okay, we'll call. 38 or additionals. Yes.
It's not itself, 100 quota, 24 days behind the
Yes.
নিম্নলিখিত পদকীয়া নম্বৰ লোৱাই হয়। মই মোৰ ছোৱালীজনীক আজিৰ পৰা 15 বছৰ আগত বৰিগাঁৱৰ নিম্নলিখিত পদকীয়াজনৰ লগত বিয়া দিম। আমাৰ আগৰ পৰা মোৰ ছোৱালী আৰু পদকীয়াজনৰ লগত সৰু সুৰা কথাক লৈ কাজিয়া হৈ থাকে। যোৱাকালি ইংৰাজী 30/3/2026 তাৰিখে প্ৰায় 8মান বজাত পদত্যাগৰ সভাকালিয়ে মুখ্যমন্ত্ৰীকে জনাই যে পদত্যাগজনে মোৰ ছোৱালীক সশস্ত্ৰে ঘূৰাই ফান্দ মৰাৰ চেষ্টা কৰি গুৰুতৰ জখমী কৰিছে মতে সংবাদপত আমাৰ ঘৰৰ পৰিয়ালে মোৰ জখমী ছোৱালীক বেজাৰা হস্পিটেললৈ লৈ যাওঁ যদিও জখমীজনৰ গুৰুতৰ দেখি মোৰ ছোৱালীক DMC গুৱাহাটীলৈ প্ৰেৰণ কৰে আৰু বৰ্তমানে মোৰ ছোৱালীক DMC my 15 years they married already gone 15 years, but they have 2 minor children. But one is girl, he is dumb. So my lord, they are taking care by the elder brother of the national law. So my lord, 24 days he got the may be allowed, but again they will come again, they will continue their conjugal life. Due to some altercation, my lord, actually my lord, actual fact is that my lord, the informant wife of the my lord, he wanted to commit suicide, lord, and he tried to my lord defend her, lord. His second, lord. 4 days behind the bar, lord. When my 15 years, lord, peacefully, lord.
After appraisal of the record, learned trial rejection order was observed that the accuser attempted to kill the informant's daughter by assaulting her with a sharp weapon, causing grievous.
Appearance.
Lordship, my line observation is that, Lordship, causing grievous injuries upon receiving the information, the informant along with his family members immediately
That is the
shifted.
FIR content.
Yes.
Yeah. 24 days, my lord.
Later on, he has referred to GMC, Lordship. So section was 1192 and 109. So how much injury was there? So at least I pray for case diary at this stage.
Have you furnished any medical document regarding her recovery or any statement recorded, because you have submitted that she already recovered?
She already reported. She is her parental house, lordship. That may be reported on the order, lordship.
No, in that support, have you furnished anything? No.
No, ma'am. He's in the jail,
And
lordship.
how can we say?
It is not in the jail, lordship.
He is on jail, no issue. No,
Well,
regarding her recovery, is there any document or is there anything that her statement is recorded? Because as per the FIR, she was still, at the time of lodging the FIR, she was very unconscious.
My lord, that might
Uh,
may be reported.
Okay, can you, where from it has to come?
My lord, what happened? Two minor children, my lord. They are taking care
From
of the
Dorong, I think, see that it.
Wrong,
Treatment.
please.
minor children. This is why, my lord, they are taking care of
22nd, if possible.
You can give 22nd.
That best early that prior to that, it is not possible to come.
children are taking care by other person. The honest is damn lordship. That's the problem, lordship.
Second video along with injury report. 22nd of May along with injury. No, along with injury report. See the seat. She already signed.
Number two. Application, mother. Lordship earlier gone through the FIR method, like one of the quickest method. Lordship is granted in bill method. But it is, look, it's not one of the fact is that method. Informant is the nephew of the petitioner's mother. And he earlier lost the FIR method, which is available in nature method. Subsequently, the second FIR has been lost method. And in this case, method, they were asking for method. And co-accused lordship has granted interim bail, my lord. I have connected the order also, my page 60, my lord. And the other co-accused, my lord, they approached before the learned session judge, my lord. The learned session judge also, my lord, granted interim clearance to some of the co-accused. That order also I have annexed, my lord. So I paid, my lord, co-accused, which your lordship has granted bail. It is fixed on 25, my lord. For case diary. Interim grants contact with them. 60 and 64. Land dispute, my lord, in between the family members. Part, my lord, the sections were charged which are available in the
Where is the FIR?
FIR, my lord, case, and my lord, page 12, my lord. And, operating part, page 13. Second FIR, my lord. After that, caused by the same informant, my lord, that's on page 20, my lord. That is, I don't 23, so that when they came to know, they all the sections are available in it. They lost this instant FIR on 21. And about there is a land dispute, my lord. And which is, my lord, the name of the petitioner's father, my lord. And
Goswami, the co-accused was there. Ismat Ali. One
One-
Ismat Ali.
Kismat Ali.
And he was granted interim protection was granted to him. So ground of parity may be considered, I think.
Lordship,
12.5 for production of update. What had happened thereafter?
because which case? Lordship,
No, where I mean interim was granted, it was fixed for case diary on 12.5.
12, my lord, on that time, CD not come. My lord.
Oh, CD was not
25,
received.
my lord.
Okay,
25.
20. Is
Is
61 of the order আছে same submission কৰি দিব আৰু খালি এটা submission কৰি দিব one of the co-accused has already been granted interim TLS considering the case of petition in the same he may also be granted with submission in line to packet বাকি নেই 61 62 টাকা same
20.
okay we're ground of priority we are considering it it was fixed on 20
20, my lord.
20
6 months.
20 করে
AB number 873, my lord.
20 করে দিব along with AB number 873 of it. Okay. Appear before the IO, cooperate in the investigation.
3.
Hmm.
In this particular case, and you got the FIR is the case 30, the one number. Very.
Hmm.
Offer. One for genital erosion is. গোয়া এই 3 তারিখ 2026 তারিখে রাতে প্রায় 2 মান বদা মূল মেসনাগুটি উদ্মারি স্বার্থখণ্ড অবস্থিত ঘর নিম্নলিখিত প্রতিক্রিয়ার জন্য খবর আরো এজন পদকীয়া মূল ঘৰত অনাধিকাৰ প্ৰৱেশ কৰি মূল ল'ৰা শত্ৰুল ইছলাম থকা অৱস্থাত হেঁচি তুলি বিচনাত বান্ধি থৈ মুখত কাপড়ৰ টোপোলা সোমাই দি ই ৰিক্সাৰ 8টা বেটাৰী এখন ই ৰিক্সা এটা মোবাইল ফোন 10,000 টকা অবস্থান চুরি কৰি লৈ যায় মই 1 নং পদকীয়াৰ ঘৰত ৰাতিপুৱা যাওঁ এই বিষয়ে অৱগত কৰিবৰ বাবে কিন্তু পদকীয়াজনক সৰু ভাইয়ে জনাই যে তেওঁ কামাৰ ঘাট গৈছে আৰু 1 নং পদকীয়াৰ দেউতাকে জনাই যে মোৰ ল'ৰাই চুৰি কাণ্ড কৰিছে This is the main content of the affair. Okay. The real fact is that the two petitioners this two petitioner but the employee of the informant
King Puli?
employee the informant has a broken items damn lordship. These two petitioners were working there. Now they have left their job regarding some salary disputes. And in this regard, lordship, some altercation has been taken place with some days ago. Lordship. Thereafter, Lordship, informant Lordship, this present affair has been lost. The two Lordship take revenge on that Lordship. Nothing is there, Lordship. He has never visited to the residence of the mentioned in my petition. Lordship. There are 4 Lordship. He has visited the house. He has mentioned.
Mr. Goswami, now the next theft is okay. There is
Yes.
an allegation of theft. The later part is that he visited to the house of accused number 1, and then his younger brother told that he is not available, or his father said, yes, my son had committed
Theft.
the theft. That can it be this kind of thing?
Yes, that part is,
That part is quite
He clearly mentioned that he is known, this petitioner is known to the public.
that is so known. Unknown is not there.
They may be protected, it may be careful.
theft part was there, Lordship. Allegation is,
Theft is already there. And regarding recovery, do you want to submit anything? Recovery?
Lordship, they have
Not
nothing in
committed
knowledge
at all.
about that part, Lordship. What happened to this house? Totally unknown. They are working now in different place.
Mr. J. Islam did not counsel for the petition. DP Goswami did an additional people everyone. This is an application for section so and so. Is submitted by Mr. Islam that the present two accused petitioners are innocent and they have not committed any such offense as allegedly have. The informant had a temp wherein both the petitioners were working, but they were not provided with salary, and due to that dispute, they have left the work of they left the work and now engaged themselves in other works. Only on the said grudge, the concocted allegation has been brought against these two petitioners, and the petitioners, however, they are ready and willing to extend their cooperation in further investigation of this case if they are content with subject. Next, Mr. Goswami, the learned petitioner, substituted. There is a clear allegation that in the house of the informant, hence he insisted call for the stay. Considering the submission made by the constitutional the case record and other aspects of the case, this court is of opinion that an interpretation will be under interim protection, appear before the IO and cooperate in the investigation. Yes, Goswami, when it can be?
Lordship, it's from Gubri. 5th of June.
5-6.
Or there is bail application mallet. Conjure 3 is there mallet. Conjure 3 is there mallet.
Oh,
Bail is the case diary. Lordship may call for the case diary along with post-mortem report by Lordship. And similar matter is switched on 21. This March mallet.
out of same FIR.
Yes, mallet. The bail is on 09.
CDB call for along with the PM report. List the matter record along with what is the number?
1109.
1109. It was AP, BA, what is
This
it?
is BMI.
BA.
Along with post-mortem
Well, it was fixed on 21.
21.
Okay, by listing it on 20.
Bye.
However, finance states that they are not the petitioners document of made it that it
Yes, yes.
with due respect, I would like to state that on 12/9/2025, at about 6:30 a.m. in the morning, some of our villagers, namely Monwar Hussain, Abdul Sattar, Bandar Ali, Monuddin, Nuruddin, Akbar Ali, Sohar Ali, Sultan Ali, and Surab Ali of Raukwa, Arbi, and Fatpur went to storing the flag on about 25 feet of land already at about 8 a.m. in the morning. When they were doing flag counting, so the accused persons causing serious injury by assaulting the affected person with message, Aki, Zoom, Dega, etc. One of my uncle named Kumar said, this was another uncle named Sattar Ali. Brought to before Reliance hospital and injured condition, but doctors declared both of them dead, and other injured persons were hospitalized critical condition. It is relevant to mention here that at the time of incident, according to Ali Tattar, Asad Madani, and Shamsul Haq of our village assaulted by the accused persons when they tried to rescue the injured person and got injured. So this is the FIR of it, and specifically 28 persons were named, 27 persons were named. The petitioner were not named in the FIR. The petitioner number 1 is 76 years old. Petitioner number 2 is 59 years. Their house is adjacent to the place of occurrence. On hearing given cry, they went outside. They do not have any land, nor they are connected with other accused persons. Because of their presence at the place of occurrence, now they are apparently arrested. Accordingly, they filed on bail application for the learned passenger, but that was rejected. Their involvement is that their house is adjacent to the place of occurrence and they were. And I have categorized this area for that they do not have any land or they are not participating in the state area.
Only here is the case is registered under section 103 and one person has died also in this incident. So at this stage, I prefer case diary only.
I'm paying section on the ground also that is the age ground and what they are not named in the FIR. If anything is found in it, anything is found against them not in the case, they are not to consider. But considering the age and the allegations made in the FIR, because the FIR was lodged 1 day after the alleged incident. Incident occurred in the morning and the FIR was lodged on 30. Even then, not if 27 persons were named, these 2 persons were not. If they are the person who actively to participate in the occurrence, their name also have been there out of 27 names. Immediately there was group fight between 2 groups.
27 persons are named, but you see 28, there are others.
And
But if they have taken active participation in the occurrence, their name also have been there. That is why I'm something to your knowledge.
only thing I want,
The persons who actively participate in the occurrence, their name comes first, or in the FIR is somewhere. These are the persons who assaulted the. So that part is not there. On that count, I'll say.
only
And he is 76 years old. Petitioner number 1.
one thing I want to point out, Lordship, case 28, Lordship,
28.
28.
Yes.
May I read, Lordship?
Hmm.
Upon perusal of the case diary, it appears that the investigating officer has recorded the statements of the informant and the victims as well as many other persons who had witnessed the incident. It also appears that some of the injured persons and the eyewitness were also brought before the court and their statements were recorded under section 183 of BNSS by the magistrate. During their examinations, both under section 180 and 180 BNSS, the said witnesses and the injured person have categorically implicated the accused petitioner Ali Akbar of having caused injuries to Monwar Hussain on his head and Lathi along with accused
Hmm.
Zail Haq.
Acha. Monwar Hussain died.
So, even short
Acha, Monwar Hussain to died. Yes, yes.
Homework.
Okay, we'll call for the case diary. So rightly pointed out
if
by
nothing found, then
because out of his assault only Monwar Hussain died. As per the order. Yes, then the observation means from the case diary only that observation has been made. Yes. So from where it has to come?
Goalpara, date, I think, for that time. For that
From
time,
that in the month of May to, I don't know whether yes, can it be? 28 will do, Mr. Let us see. 26. Okay, that's city.
Please. Where is the litigation?
Yes,
Here is the.
yes.
It's the section 360 A and
376 also there.
Yes. The occurrence took place in here 81. And
It is a charge sheeted case.
Charge sheet.
Oh, acha. So what is the stage of the case? Is still yet to be committed. So have you received this summon notice or warrant? What is that?
I have received, I applied for clearance.
Acha.
That's why I have.
Okay, then next date, when next date, can you tell us the next date fixed?
It is not.
June, yes, first week of, or because we want to fix it prior to that date, that's why I'm asking. In the month of June, mid of June, mid. Then we can get first or second of June. Let us call for the scan copy of the case record.
along with the
Can-
along with the case diary
Along
also.
with the case diary, registry will do the needful. Wait, list, yes?
It's a case of 376.
Oh, acha, 376 is there now. Notice be issued to the respondent number to speed post and usual process. Let the matter be accordingly listed on 1st of June. 1st of June. Yes.
Case and where petitioner here, he has love affair with the informant for few months.
Hmm.
But after that, she said that I was poor at that time, madam. So she rejected me. So I went back to Malot and I am still working there. And in the meantime, Malot affair was finally made and charged. And then the case is also still pending in there. And Malot,
This is a charge sheeted case.
yes, Malot. The case is there, Malot. Malot in the year 2022, Malot. Malot, I want to take Malot.
Hmm.
Here, Malot, dated 23/9/2022. Here, he said, it's not that the yeah, also, and his warrant could not be executed. And my lord, in this way, my lord, NBW. And I was not aware of everything.
So NBW was issued since 2022.
Yes, my lord, and still it is there, my lord. And I was not going, my lord. And my lord, therefore I am here, my lord. I actually grant me bail, my lord, so that the cure of the trial is start, my lord. This is my
So at this stage, your PNA is also issued against you.
proclamation, my lord.
You have annexed the order sheets of only two
Only
order sheets.
22.
How can we know
The
by
last-
the two order sheets what is in the now present position, whether NBW, PNA or was issued, or what steps taken by the learned trial court below? We are not. There is nothing.
Yes, my lord. My lord, actually, my lord, there is a bunch of orders, my lord. Same thing, my lord. I have also, my lord, I have,
We have gone through. We have not gone.
which is orders with me, my lord. My lord,
Then that way you cannot submit.
my lord, that's why, my lord. Thank you.
Okay, then in that case, we are calling for the scan copy of the TCR along with the case diary. It will reveal the record also, order sheet also. Okay, then we can see.
Yes.
Because since 22, your NBW has been issued against you.
Yes, sir.
So for now, say 22 is there gone, 23, 24, 25 is
4
gone.
years.
Now we are in 26. So after 4 years, position would not be same. Na? Initially, matter would have been different, but now to it's second. Anyway, we're calling for the scan copy of the TCR along with the case diary list. From where?
It is from Sri Bhumi.
Sribhumi. Yes. 2nd of June. Next date, can you tell us what is the next date?
My lord, the next date is 29/6.
29/6. So we are listing it on 2nd of June.
2nd of.
Registry will do it.
Okay,
16 in this case, charge sheet submit.
Charge is submitted. He was on interim. Let us see. Pardon? So you are already in interim, so appear before the London trial court below. We are extending your interim. Okay. Interim will be extended. You are already on interim. So appear before the London trial court below. And that will be considered, no issue. You are MS, Mr. D. Saikia. Heard Mr. D. Saikia, the London counsel for the petition. Also heard Mr. D.P. Goswami Swen. So yes, what is the CS number?
My CS number 52/26, dated 19/4/26.
As the petitioner is already on interim bail, he is directed to appear before the London trial court below, or to either to make the for regular bail oblique to make the interim bail absolute. Your interim bail may be absolute by the others for the London trial court below, or it may be on regular bail also. Yes, yes. Next date, can you tell us? Next date. Next date fixed by the London trial court. Can you tell us? No. Then within 15 days. Within 15 days. We're extending your interim up to 15 days.
17 also charge sheet submitted, Lordship.
Yes, it's a count I have to wait another one.
Session tribal is okay if there are two options. One is if it is sessions tribal. In that case, there cannot be any. It can be. It can be committed immediately to the sessions court, because for your appearance, the court did not wait. One thing. So you can very well approach before the sessions court. This is a trial court. So that case, otherwise, if you
cannot approve the title.
no, approaching is nothing to worry, because you are already behind the bar. So there cannot be any other order except your extension of behind the bar, that much only. So try to get the case record committed immediately to the session, just so that you can appear. Otherwise, if you suppose that order should be there, then we are not in a position to say anything from where the charge sheet number, case number, nothing is there. So it may be difficult on our part also. Hard, Mr. Hey, hey. Heard Mr. A. Kanikar, the learned counsel for the petition, and also heard Mr. D.P. Goswami Swenso. Case was fit for case died, but it is submitted by Mr. Goswami. That case has already been charge sheeted. Yes, CS number.
CS number 37/26, dated 29/4/26.
So we will give you the direction to appear before the learned trial court below with a regular application for pay. Pardon?
What did you also made like
Yeah, we are directing the petitioner to appear before. Matter is disposed.
18.
18 also charge sheet submitted, Lordship.
কি করবো, কোনো আহা নাই। আগৰবাৰো done active. এই গগৈ এবাৰ আহিছে এইটোতো none appears on call for the petition. Full stop. Heard Mr. T.P. Goswami, the learned additional PP appearing on state. And it is submitted that the case has already been charge sheeted. Right, CS number, yes.
98/25 dated 5/10/25.
5/10/25.
Not
Acha. 5/10/25. In view of this, the petitioner is hereby directed to appear before the learned trial court below with a regular bail application. Back in 15 days. It is
24.
Yes. What is the position of 24?
CD is received. Sometime.
Earlier, a wrong report was submitted. Subsequently, it has been submitted.
Yes.
So now we have received the proper
Yes.
case diary.
CD has been received.
Here, R.S. Mishra, B. Sharma, and B. Dev. Let us await for some
Yes,
time.
let it be after some
Yes.
time.
25.
My lord, I think IT got our consent, it has been got. But there was a new order.
We have extend Purchana.
CDs.
We are already extending your entry. Now, question is that in item number 20, there was a prayer that they are going to file an additional affidavit. 2-3 days they sought for. And item number 21, 22, the council was also present. There is no objection. So I thought that these are the connected matters, all the series of matters. You all are on interim, so we are extending the interim to all. And we stayed on 22nd of May.
25.
Yes, what is the position of 25?
Yes.
CD was received, it was retaining, na?
25 Lordship CD has been received and he is on interim. But Lordship, the statement of the petitioner is not in the case diary. So we'll have to update the CD Lordship.
Actually,
Otherwise,
CD
you can-
was received on the last date, it was retained.
Yes. I found Lordship that the statement of the petitioner is not in the CD. So
Achha.
let us update the CD Lordship.
Then appears on call for the petition.
Update quick.
So hard Mr. B. Sharma, run an additional PP. It is submitted that the case diary is received. But the statement of the petitioner is not available in the case diary. So the petitioners were petitioner was granted with okay, but now petitioners were granted with the interim protection. In view of this, Mr. Sharma submitted that an updated case diary may be called with the call. Next, in view of this, later see case diary be returned, calling and calling for an updated one, directing the IO to furnish the updated case diary along with the statement of the petitioner is already recorded. And further, if the petition, the statement is not yet recorded, the petitioners, they are directed to appear before the IO within 7 days from date of order and to record their statement. List the matter when it can be listed.
Lordship, let it be in the month of June, Lordship. 8th of June.
8 of, yes. You are appearing here.
Yes.
What's your good name?
Very good.
MA?
M.A.
Student of record for you.
Yes, sir.
We have received the case diary, interim be extended for you. But your petitioners, your petitioner statements are not available. So if they already appeared and if their statements as recorded, we are asked the IO to furnish the statements. And if not, suppose you have not appeared or your statements have not been recorded, then you are directed to appear before the IO within 7 days so that your statements can be. Otherwise, listing it on 8/6 and your interim will be done.
27.
Yes, 27 CD receipt. Yes. Oh. Is it only a chain snatching because 1182, 109, these are also there, sections? How? Oh, acha, acha. Or this chain snatcher are the victim here. The injured implicated you. The injured implicated you. Hmm. Where is the medical? And what is the statements of the accused person? Is there any? It's stated that there was a scuffle and all, but they did not assault. But very surprising, the medical report speaks otherwise. Now, apart from that, what do you want to submit is, because if the photograph shows that some sharp cut is there, but the object used by as per medical is the blunt. So I don't know why. Twenty-seven. Heard Mr. Peter still under counsel for the petition. Also, Mr. P. Sharma, the learned additional to be on the status. This is an application in connection with CD receipt. Where is it is submitted by Mr. Das that after obtaining the order of temporary arrest paid, the accused petitioners appeared before the IO on 13/4/2026, but that day their statement were not recorded. And as per direction of the IO, they again appeared before the IO on 30/04/2026, when their statements were recorded. But they are still ready and willing to extend their cooperation in further investigation of this case if they are granted with the privilege of pre-arrest. Mr. Das further submitted that there's a in the during the period of incident, there was Rash Mela in Albari district, wherein these two petitioners were assaulted by some public on the allegation of chain snatcher. But as the petitioners were also present there, who were known to them, the murder of the victim, lodged an FIR against the present petitioner. He further submitted that earlier the wife of the accused petitioner number 1 lodged an FIR against the victim, alleging assault and grievous injuries on him in the year 2023. So, thus with the previous grudge only, the present FIR was launched against these petitions. But next para, Mr. Sharma, the learned additional PP, submitted that from the statement made by the victim as well as some of the witnesses, it is seen that these are the persons who assaulted the victim, causing various injuries on his person, who was accordingly admitted in the hospital. However, it is submitted that as per the medical report, the injuries sustained by the victim was simple and caused by blunt proximity. But the photographs annexed with the case diary shows that there was subcut injury, also subcut injury sustained by the victim. Next, however, it is submitted by Mr. Sharma that both the petitioners appeared before the I, cooperated in the investigation, and the statements have already been. Considering the facts and circumstances of this case, the medical report vis-a-vis the other materials available in the case diary, this court is of opinion that further interrogation may not be necessary for the purpose of investigation. In view of this, it is held that the accused petitioners are entitled for the privilege of pre-arrest bail. And accordingly, the order of interim pre-arrest bail dated 7/04/2026 is hereby made absolute with same terms and conditions.
30.
Yes, charges submitted here. Okay. Are you on interim the earlier?
Yes.
Have you appeared before the IO?
Yes.
Yes. What is the CS number? Heard Mr. A. Datta, the learned counsel for the petition. Also heard Mr. P. Sharma, the learned additional PP, appearing on behalf of the state respondent. It is submitted by Mr. Sharma that case has already been charged sheeted by its CS number 65 so and so so and so. In this context, Mr. Datta submitted that after obtaining the order of pre-arrest bail, the petitioner has already appeared before the IO and cooperated in the investigation process. Next para, as the case has already been charged sheeted, the petitioner is hereby directed to appear before the learned trial court below with a regular bail application, which may be considered in accordance with. However, till 15 days from the 15 days, the interim granted earlier will be extended, enabling the petitioner to appear before the learned trial court. With the above observation, the present. Okay, we are extending your interim for 15 days.
31.
Yes. No cases. Obviously, liberty will be there. Always at liberty. At every moment. Heard MST so, the learned counsel petitioner, and also heard Mr. P. Sharma, the learned additional PP, appearing on behalf of state report received from All Women Police Station, received from SI and OC of the All Women Police Station, wherein it is reported that no case has been registered against the present petitioners in the said police stations. Let the report be tagged with the case record, and as no case has been registered against the present petitioners, the present anticipatory bail accordingly disposed of. However, the petitioner can approach the appropriate forum in the event of registering any case in the said police station, under the said police station.
Level number 24, 1990.
So in that case, you have received a case diary, na? So what to do? It will be returned or what to do?
Click on item number 8.
Then give up. Yes. Initially, no, initially what was the amount? 7,000 and no. Initially, subsequently they preferred in for enhancement petition. So initially, what was the order? What was the payment? 6 plus 2. 2 for the child. And hence to 15. 15 plus 5. So after deduction, you are getting 45,000 or prior? After deduction. That means after deduction. What is the deduction amount? Your petition, your respondent is ready to return back. Oh, this is as per you, this is not the updated one. No, this is what is this then? What is this? 25. Month of May 25. So you want updated salary, please. No, as per you, I don't know, there may be some increase, but here as per the salary certificate, The gross pay is 81,660 and the net payable obviously is 60,910. What to do? He is submitting that one attempt, can it be made? One attempt. But sitting where? By in presence of you in any place or where you want to sit? So if you need a mediation center, we have to send it for mediation then, in that case. It can be sent, no issue. Already one order is there, so I cannot pass any other order. One order is I have seen. Yeah, until 13/5/2025, one order was there, I think. Already fine. Already fine. What I'm saying, Mr. Ahmed, this one order was passed on 13/5/2025, wherein he was directed to pay out of 20,000, 15,000 was to directly pay. Now you are getting that amount or what? She's getting that. But will it be possible for, yes, rightly is submitted, will it be possible for you? That is from your side. I'm just asking whether it will be possible on his part. So when do you want in that case? No, second in your sitting will be before mediation. Our report will be on 9 June then. You want any date to be fixed before mediation also? That's what I'm saying, because he will come from, say, out of state. So let us fix a date before mediation also, so that you can appear there and can talk about. In that case, your mediation, let it be on 2nd of June, the mediation. It can be done, I think. Be better to fix, because otherwise, heard Mr. S.C. Biswas for the petition, and also heard Mr. Ahmed, A.M. Ahmed, also for the respondent. With consent to be, it is submitted by the counsel for both the parties that one attempt may be made for counseling before mediation. In view of this, let the matter be placed before High Court Mediation Center. The registry will do the needful and to appoint and to mediator for the present case. Further, both the parties are hereby directed to appear before High Court Mediation Center on 2nd of June, so and so. In the meantime, the petitioner is also hereby directed to produce the updated salary certificate of 2026 before this court on next date of listing. Matter will be second June not and we are fixing here at 9 on 9/6, directing you to appear before the mediation center on 2nd of June. In the meantime, you produced your updated salary certificate for the month of 2026.
Number 9.
Yes. In that case, whether I should try this case one, better not to take. I must. Huh? CD you have received. Yes, it is. It is for quashing. I can answer, but I have dealt with two matters of civil. So, what to say? Huh? I don't know what to say. Yes, obviously you have come from you have. No, don't make such kind of submission, Mr. Counsel. He is praying for some accommodation. It may be allowed, may not be allowed, but you have to hear, don't make such kind of submission before this. Now, till tomorrow also you are here? No. Tomorrow too, I cannot fix all that. No, we want to accommodate you because you are outside counsel. We can understand this one. So that is the reason why we are accommodating you. Now, there may be some reasons for the in this council, Mr. Das. One that I don't know, on the last occasion, most probably they immediately filed the written objection also. So that is, from that view, it is the first date of hearing. That is, if there is an interim order, there is the investigation is not proceeded now. Acha. But what about the investigation, Mr. Law? Is investigation is still proceeding or proceeding? And no coercive action is taken now in CID. One more thing, actually, I do not want to take the matter also because what I have done while passing the judgment and order in other two civil matters, there were some observation by this court made by especially this court. So, in fact, for personally also, I don't want to take this one because their observation may affect either of you, both the sides. Better to not to take, I think. Better not to take by this court because there are some observation has already been made by this court. So better not to take. Now you are Mr. Chayan. Now tell us as per your convenience, are you going to retain the case diary or you want to send it back? Case diary. Then and then that's what I'm saying. As per your convenience only, we are going to, and we'll pass the order in that regard only. Yes, just tell us when it can be. 21st of June. 21st of June, he will not be here. 4th. 4th of June. 4th of June will do. Yes, yes. Mr. Afridi, you just want to see because from the July 1st, most probably our vacation will start. So the first week of June, he may have some secretary. So that's why he's saying 21st of June. Let it be either after 15th, any date convenient for on June, month of June. Any date convenient after month of June. No, information is not, he has to accommodate on that day also. Nine to 26, then it has to be. Tomorrow not possible. For this court tomorrow, বেলেগ কোৰ্টত দি দিব পইণ্টটো এনেও নলওঁ এইটো বেলেগ কোৰ্ট এডজাষ্ট কৰিব পাৰিব নেকি? Postmaster is saying that tomorrow may not be possible because list is already up there. কালিটো list ওলাব 18th. Mr. M. Chaya, the learned counsel for the petition, and also heard Mr. F. Faridi, learned counsel for the respondent number 2, and Mr. P.S. Lockwood, learned additional PP appearing for the state respondent. CD is received, but it is submitted by Mr. Faridi that due to inconvenience on the part of the NK senior counsel, Mr. D. Das, he prayed for some accommodation. Considering the submission made by learned counsel for both sides, it was found convenient to fix the date on 18/6/2026. Further, with a further direction to put the counsel for the petitioner to go for the proceed with the hearing on the next day without any further adjournment. Mr. Lockwood will also return back the case diary. An updated case diary may be called with a direction to the IO to submit the case diary on or before, positively on or before the next date. Further, it is request to the registry to list the matter in any other court without me. Post of it. So we are listing it on 18/6 with a direction for further adjournment with no further adjournment. That part with direction to the IO also to furnish the case diary updated one within honor. Okay. Yeah, otherwise, we are listing it on 18/6. Yes, sure. Sorry. Interim order be continued till next year. Please send back the CD for updation. that context, we can say that she was not in a position to marry because there was no divorce from the earlier husband. She is a married woman. And if you go by the case of the accused also, he also knew that there cannot be any marriage, and simply false pretext of marriage is the sexual intercourses were going on. Same context you can see. If her intention was definitely she's a married woman, she cannot marry him without her divorce accepted. But he also in the same situation or same footing, that he also know that he is not going to marry her because she is a married woman. That is there only. If he would have been a person, suppose, then that was there. Yes, anyway, this we have submitted. The consensual relationship, there is no dispute. That was consensual, no issue. Consensual, but false promise was there. That is the issue. Undoubtedly consensual, no issue. This is the case wherein it's not a case of the washing and all. It's a case passed by the here. Subsequently, proceeding was quashed. So this Samadhan versus state of Maharashtra, the Prashant Das versus state of NCT Delhi, these are discussed. Okay, yes. Do you want to submit that there was consensual relationship and with the she was very much acquainted with the fact that she is a married woman, so there cannot be any false promise of marriage from the other side, unless there is a divorce from her earlier. Apart from that, yes. Yes. So under 420, what do you want to say? Given the judgment, what it says. So that what is the relevant para you will cited. Completely. Okay. Yes, Mr. Ali, any other? Yes, what the topic? Then she leaving her 2, 3 children, husband, she went with. Being a married lady, having 2 children, she avoid all these things, keeping, living apart her husband, her children. She went with. Why she went? Oh no, she is already married. So what kind of promise of marriage? She's already married woman, having 2 children, having husband, loving relationship with the husband. Apart from leaving all this, she went. Then what from you? Whether she will be able to marry a person without divorce, without making any divorce with her husband? Huh? She can marry. Huh? Yes. No, she can also marry. Women can also marry. Yes. Then why she agreed? No, why she agreed? No, let's forget about magic. Magic is nothing to do here. Why she can also marry? A male Muslim can marry 4. Yes. She can also marry 4. Then, then what kind of undue influence? You are married woman, I'll marry you. That is the undue. No, she is a married woman, but I will marry you. That is the oh, magic. Forget about magic. Magic is no role here. What kind of magic? Magic is no. He did not made any hue and cry. In 15 days in a house, he was there. But she did not make any hue and cry. She did not sought for any help. Why she did not sought for any help? Okay. Hmm. Very nice. She herself did. It is it is she only who destroyed her entire marital life by indulging with sex with another person. That is the case. Yes. Hmm. Yes. These are the steps to be looked into. Yes. Okay. Yes, Mr. Yeah, Deep one. I guess it. Deep. Ini next week may not be possible because May is already over. Month of May is already over. at best on first week of June on any hearing. Okay. The request by Learning Council votes authorization. Then any hearing. 4th of June is a Thursday, it's a hearing day. Okay. 13 is a matter of washing or what? Yeah, PP, you are here. Or who is there? No, but whatever, but I mean, who is the other side? Respondent is sole respondent. Acha, notice received by brother. So we are deemed to serve. Okay. It has been reflected. So you are challenging one order. 50. So a 2711 is the rejection order or what? Or it is the ex parte order? So where is the rejection order? No, no, it is okay. I can understand. If an ex parte order was passed in your absence, so thereafter you have filed a petition for vacation of the ex parte order, and you have submitted that prayer was rejected. Where is the order? We need that order, no? That you have approached. 51. It was a petition before for vacation of the ex parte order. Yes, then. Hmm. Yes, obviously. This is the order by which the prayer for vacating your ex parte order was rejected. And your ex parte, initially the ex parte order was passed in, you have just submitted this 60 page. You have annexed that order also? Yes, where it is. 48. Is the ex parte order, no? So now what is the position? The execution is going on. Are you paying or you are not paying it? Then please forget about those matters. Now you are before this court against the order of rejection of your ex parte. So what was the ground for your ex parte? Why it had to be ex parte? Well, it was given, I think. Opportunity was definitely given to you. You did not avail those opportunity, remain absent, so ex parte was there. So now what was the illegality in passing the ex parte order? That's what I'm asking. Because of your physical illness only. So how many days you remain absent? So you have filed your WS. WS was earlier filed. The order sheets have you annexed whereby you are absent with step and all these order sheets are there? Since from which page? In page number 32. You know, So 32 is the 12-12-24 order. That was in a miss case. Miss case is okay because most probably miss case was for interim and all. So now your case is you have submitted that you filed your written statement. Pardon? Your this case, your maintenance case. So whatever. Now the question is that on 18/12 there is an order. Then 4/2 is an order. When you have filed your written statement? 120. Acha, 1325. Try to dictate the order. We'll continue hearing. Show us the reasons of for your internet, whether medical is there or not. Ajit. Oh, no. So now, in your just now show us the petition. No, the you have filed your WS on 1/3/2025. It is in page order in page 38. Na? Oh, okay. This is your I mean WS, and it reveals from 1/3/2025 order. 1/3/2025. So in page 36, it reveals that on 1/3/2025 you have filed your WS, right? And WS, whatever plea you have taken, it's okay. But thereafter you remain in 2 consecutive dates. You were in part 21/3 you were there. You are present. Acha, interim was already there earlier. Acha. And the through mediation also it was there, na? Then 12/12/2024 interim was done. So I just want to say that on 23/4 there is an order that you did not the parties did not reach any settlement. And on now from here onwards, 26/5/2025, you remain absent with same. On 26/5/2020. Yes, yes, you are present. Did not reach. You are present. That's what I'm saying. You are present. You remain absent on 26/5/2025 with state. So then evidence and payment was there. And on 13/6/25 again you remain absent with state. Okay. Then 14/7 also you absent. Directed to comply with the to make payment of the interim maintenance. Mm. On 18.8, it did not furnish any medical ground. And supposed to proceed ex parte. Arguments are heard on that day itself. On that day itself, the argument were also heard. Okay, then the ex parte order was passed. And where's your the petition? You have submitted petition, is that? If- But suffering from serious physical illness, what kind of illness? If there is any supportive medical documents were submitted by you? No, whatever, those annexures are where? No, medical, you are supported with some medical documents. Where are those documents? It may be available here. তারে বুঝতে নেই। On petition of 9/10/2025. এই petition করার উপর। দেখুন, affidavit acceptance, right? Not finding any medical. That means you have not filed. No, supplied by me is not the question. Question is that have you filed any medical document? No medical document is there. See this, it will deduct. heard Mr. You are Mr. Nasir or Nasir? You find out and just heard Mr. S.R.A. Nasir. Learn it for the petition. None appears for the sole respondent as the case has already been proceeded ex parte. As the sole respondent did not appear in spite of receipt of the notice from the court. Next paragraph. This is a petition, section 442 BNSS, related to section 338 of BNSS for setting aside and quashing of the impute order dated 27/11 passed by learned subdivisional SDGM Karpiang Law, Kajan, in Miss case number 13/2020, rejecting the petition number 558 dated 558 filed by the petitioner praying for setting aside the ex parte order. Order. Your ex parte order was dated 27/11. The order dated 27/11. Have you received got any? Oh, half this, na? Okay. That is a code below means it is not the complete record as per you. It is only the complaint petition and orders. That part there is nothing. Other yes, that is also not available. Then we have to call for it. You can also file, and that part we are also calling. Why half this year has been sent? Okay, Mr. S.S. Nasir Leacock, so and so. While taking the hearing of the present admission hearing of the present case, it has found that the scan copy which has been received by this court is not a complete one, and the petition which was filed praying for a vacation of the ex parte order, the annexures filed along with the petition, that is the medical documents, etc., and other relevant portion is also not available in the case record. In view of this, the registry is hereby asked to issue reminder to the concerned court, directing the court to furnish the entire scanned copy of the entire case record, including all relevant annexures, petitions, etc., and the etc. Further, the learned trial court below is hereby directed to furnish the scanned copy of the TCR on positively on or before the next day. We have not passed any order. In the meantime, you can furnish it. Because that is the main document. Your ground is only the illness, isn't it? So there has to be some supportive document. That's why I'm saying. Now, at the time of filing WS, you have not filed it. That will be considered at the time of filing at the time of disposing the petition. At present, we are not supposed to. Can it be on first week of June then? Let it be on 3rd of June. No, you are not supposed to bring the record. We are bringing the record. You are only supposed to file the annexure A, which was supported along with your petition. Ah, yes, yes. Then you need a longer date? Okay, as you're convenient. We have to fixing it on 15th of June. Okay. CD was called. Yes, Sharma, CD was called for here. CD from Jogi Gopal. It is scan copy. Oh, not CD, na? Why scan copy CD ki dhoro pura tha? Oh. Case is still under investigation or charge sheeted? Charge sheeted. Nadanle kana kadani. Saboti ki আছে? It is only FIR, not charge sheeted case. Charge sheet not yet filed. CD will be required. Okay, scan copy I would. Not charge sheeted, FIR only. Yes, yes, CD was last time called for, but I don't know why. URMS and Chakraborty. Hard MS and Chakraborty, the land council for petition. Okay, after giving the K-Bush, the land additional PP appearing on behalf of the respondent. CD not received, issue notice. Issue reminder, call for the CD of Jogi Kopa PS case number 91 of 2025 under section 61 to 310 subsection 4, 319 subsection 2 BNS. BNS. Yes, when it can be. Fifth of June. Yes, and then
Finding item pattern number 20.
we call it thrice. Then Mr. Sharma submitted that we have received the case diary, so better to wait for some time. Then 3 occasion we called it. No one represented. Now CD is available, I think. Hmm. He was a sub postmaster. Yes. He lost. Yes. Before SP. Uh,
FIR is at page 18.
18. Yes.
Can I
Yes.
read this? Lordship, the FIR, I will skip the first paragraph, Lordship. Second paragraph, we'll see, Lordship. The case was brought to light in the month of August 2023 during reconciliation of Post Office Saving Bank and Saving Certificate at Mohanghat Sub Post Office. During the course of verification and departmental inquiry conducted thereafter, a sum of rupees 15,28,596 found defrauded and recovery of 10,84,035 has been made from the identified offender so far. Kamal Soikia, the present petitioner, the then sub postmaster Mohanghat SO, sub post office, and presently working as so-and-so, has been identified as the principal offender along with following co-offenders. And all these are the persons working beneath him, Lordship. From this, Lordship, if I may just point out, number 2, Lordship, Noyanjodi Das, he has already been arrested and his statement has been recorded. Next, Lordship, in this case, this is important, Lordship. In this case, old transferred out RD account, that is, Lordship, recurring deposit accounts, were fraudulently closed and cash was fraudulently withdrawn from such accounts. The Department of Post sustained loss of around so and so. So, Lordship, as per the departmental rules, all fraud cases involving more than 50,000 for more are required to be reported to the police authority. So it was done. Now, Lordship, how it was done is, Lordship, the inspector of post office, Lordship, he conducted a verification. Thereafter, Lordship, it was found that around 21 numbers of accounts in those accounts, Lordship, where there are no transactions for a number of years and money is lying, for the person is either dead or he has shifted to another place and so on, Lordship. Some accounts are there which are not under any transaction. So those kind of accounts are being targeted, Lordship. And thereafter, Lordship, all the withdrawal is made from those accounts, Lordship, using the fourth signature of the account holder, Lordship. Thereafter, Lordship, in some cases, for this type of activities, Lordship, the official email ID is required and the password is of the present petitioner because he is the head of the sub post office. And that email ID, and it is called, Lordship, FINACLE ID, FINACLE, FINACLE ID, that is required for any kind of transaction. Without his approval, Lordship, this cannot happen, Lordship. And Lordship is well aware, Lordship, this ID is not to be shared with anyone, Lordship, including the employees. He is the one who is to transact on those. So, Lordship, this ID was used, and after that, approval was given and money was withdrawn in all these accounts. Lordship, here is a inquiry report. The Inspector of Post Office, Lordship, he has conducted a detailed inquiry. There, Lordship, all those accounts has been mentioned. What was the fraud done? How much was the amount? Everything is in the case diary. I am pointing out just one instance, Lordship, because this is very important. These accounts belong to one person by the name of Sunil Bormon. In his account, Lordship will kindly see. First of all, Lordship, an amount of 4,86,000 was withdrawn using his fourth signature from the withdrawal forms. Thereafter, Lordship, Sunil Bormon from time to time deposited cash into his account, Lordship. But that amount was entered into the passbook, Lordship. His passbook, it was shown, but the amount was not entered into the system of the post office, Lordship. Next, Lordship, by forging his signature again, amount of 1 lakh was withdrawn from his account. And this time, Lordship, what they have done, Lordship, the amount so withdrawn, it was not shown in the system. So that is the level of manipulation that they have done, Lordship. And subsequently, Lordship, from the year 17/12/2020 to 17 June 23, in the period of this year, Lordship, around 5,68,068 rupees was deposited by this person, Lordship, Sunil Borman, into his account. But, Lordship, all this money, there was no corresponding entry in the account. And subsequently, they withdraw every penny, Lordship, around 5,68,068 rupees, and another, Lordship, 10,76,500. This is only one instance, Lordship, I'm pointing out. There are several instances amounting to 21 numbers of fraudulent activities that was done. Now, Lordship, other three co-accused, Lordship, they are all absconding. Investigation is at a stagnant stage, Lordship, because their custody interrogation is necessary. And Lordship, the level, he in his departmental inquiry also, Lordship, notice was given to him where he has admitted to everything, Lordship, that he has given his ID to another person. This was done in my words, so I'm sorry for that. That is in the case diary itself, his apology letter. And that letter which he has shown, Lordship, where he has shifted the whole blame to Noyan Jyoti Das, that cannot be sustained, Lordship, because it was after the fraud was discovered. Then he made this attempt to conceal himself, Lordship. So at this stage, Lordship, with folded hands, I'm praying, Lordship, that he may not be granted any protection, Lordship. Because without his interrogation, Lordship, the case will not reach its logical conclusion, Lordship. And if Lordship wants, I have flag marked the entire CD, the reports, the statement, everything. Lordship will kindly see how the manipulation was done. And Lordship will kindly see the post office is not even safe now. That was the last thing for a poor man, Lordship. Banks are gone, online fraud. Now post office is also gone, Lordship. And that too by the in charge of the post office himself, Lordship. So he does not warrant any mercy from your Lordship. That is my respectful submission, Lordship.
Mr. Gupta, your name is not here. Are you appearing for someone? RS, Mr. But Mr. K.K. Gupta, the land petition, who appearing on behalf of Mr. RS petition. Petition to point. Also had Mr. B. Sharma, the land petition PP, appearing on behalf of the state. It's an application 6 information. Next, it is submitted by Mr. Gupta, the president's petitioner. He is innocent and he has not committed any such offense as an Indian. However, it is the fact that some fraud has been committed by one of the co-accused, namely one Noyan Jyoti Das. One Noyan Jyoti Das Sevak, SAVKK Sevak, who was acquainted with computer works, and the petitioner sometimes took help from the said co-accused to do some official works, taking that advantage of sharing his email ID with said co-accused Noyan Jyoti, he committed some fraud in the institution, and for which he also lodged a complaint before police and before SPD Bogota. But thereafter he was put under suspension in the year 2024, and subsequently he was reinstated, and presently he is and he is still working in the department in another district. The accused petitioner, however, is ready and willing to extend his cooperation, and also willing to provide all the documentary evidence if required during the investigation, if he is provided with some interim protection. He is provided with the privilege of re-estimate. Next, Mr. Sharma Rilane submitted in this record that present accused petitioner is the main culprit of the entire criminal fraud which has been committed in the post office. He further submitted that at the relevant time of the incident, he was working as a sub postmaster in the branch of the Dibrugarh branch. And when it has come to the knowledge of the knowledge of the postmaster during inquiry that the fraud is committed and whereby there were fraudulent transaction as many as 21 numbers of accounts by using the email ID of the present petition. He submitted that the modus operandi is there. The modus operandi was that they used to target some accounts which were not used by the account holder for long years, and they used to withdraw those accounts from those the accounts which were subsequently misused by accounts, and thus the entire fraud was committed. So Mr. Sharma further submitted that in the detailed inquiry report submitted by the postmaster, it reveals that they used to withdraw that they used to withdraw the amount, and that was not shown in the system. So the deposited money was shown to be deposited in the accounts of the account holder, but money withdrawn were never shown in the system, and thus they used to targeted those accounts, and more than 21 numbers of accounts have already been used fraudulently by using the email ID of the present. Mr. Sharma submitted that it cannot be his custodial interrogation is very much essential for the interest of the investigation, and 2 and 3 numbers of the co-accused persons are still evading arrest. So unless and until this petitioner is interrogated by police, there cannot be any logical conclusion, and for which custodial interrogation will be required, and hence he prayed for the rejection of the bail. Next para. During the submission made by Daniel Council, I have also perused the case record and the note of the IO, where from note of the IO, it is found that there are sufficient incriminating materials against the present petitioner, who was working as a sub postmaster at the relevant time of incident, and it is also found that from the inquiry report, the detail has been mentioned about the the account holders with name, and also the statement of some of the witnesses as to how their accounts have been misused by the present account accused petitioner along in connivance with the other officials of the post office. The inspector of post office also during his preliminary inquiry submitted a detailed report before the superintendent of post offices, the Booker division, as to how the entire fraud has been committed by uh, forging the signatures of the account holder and by using the email ID of the present petitioner in withdrawing the amount from the post office. Some of the victims of the witnesses have also made their statement as to how they were subjected to fraud and how their accounts, how the money deposited in their accounts were withdrawn by with withdrawn with the conspiracy with the all the conspiracy with the officials of the post office. The case is still under investigation, and except one Noyan Jyoti, the other accused persons named in the FIR is yet to be booked in connection with this case, and their custodial interrogation will be necessary to unearth some more facts about the case and also to know the uh, modus operandi of the case as to how they committed the entire fraud in the post office. Next para, considering the nature of the offense and the nature and gravity of the offense, and also considering the fact that the custodial interrogation of the present petitioner will be necessary for the purpose of investigation, wherein the fraud has been committed by the officials of the post office in connivance with the present accused petitioner. In view of this, in view of this, it is found that it is not a case to extend the privilege of pre-arrest bail to the present petition. Accordingly, this same stands rejected. Your petition stands rejected.
Last item number
So why it is in order column? Trial court record we have received. Question trial court. You are for the respondent. Respondent number 2. It was asked in the case of 125 proceeding. Okay, then we can, because it is in order column, so we'll put it for final hearing column. Otherwise, it is we have received the case record also, and appearance is also completed. Okay, it will be heard finally. It was in order column today. Okay, it was in order column today. So we are as the respondent number 2 has already entered into appearance. We have received the case record also. We can hear the matter finally. What? The copy was not complete one. Oh. You are Mr. Heard Mr. M.L. Pandya, the learned counsel for the petition. Also heard Mr. K. Bushra, the learned additional BP, appearing on behalf of state respondent number 1. And M.S. R.B. Bora, the learned legal aid counsel, appearing for the respondent number 2. Scanned copy of the TCR has already been, scanned copy now. TCR has already been received. Matter may be listed for final hearing. Registry will list the matter accordingly. Further, the appellant is hereby directed to furnish a complete copy of the memo of appeal to the respondent. Today will be able to, or you need some time to furnish the complete copy. If it is available with you, you can furnish. Achha, within the course of the day or within 1 or 2 days. Well, 16th of June will do. Hearing date. You're listing it on hearing column. It is Mohan. Talk over it on. Okay. In that case, 18, because we are giving it on hearing day. 18. 18. Ah. In item number 34, who is appearing? You are. Yes. Yes, for you, it is already delivered. In appeal. In appeal. Appeal delivers. Appeal. It is not in our order sheet. You have collected. From where? Registry has given you why they have not, annexed this report before the court. Because as per the registry, obviously it is of 2004. And you have received from the registry when 5/5. কিয় দিয়া নাই আজি নটা দিব লাগিছিল ন তেতিয়া 24 হে দিয়া আছে অ তেতিয়া দিয়া। Okay, তেন্তে registry verify কৰিম। Obviously, if it is that be the position, then we'll ask the registry, will release the matter shortly. Sorry, applicant. The applicant. When as part of stated level 5 and 26 in I directly. তাতে কি বাড়ি করবে? Uh, uh, for for stated level 5, neither ID card nor unserved notice has been received to the concerned section. It is submitted by Mr. Day that he has already received and uh, received an instruction from the report, received a report from the registry wherein it is stated that on 5/5/2026 itself, the notice was served to the respondent number. In view of this, the Law Jima Court is hereby asked to file a report in regards to service of notice on respondent number 2. Respondent number 2 on or before the next date. This is the matter record 28, you are saying? 28, 5/6. And Mr. Deka, you are appearing on 34. Your case is also awaited for respondent number 2. Same, I think. Okay, then for 04/2026. Services still awaited for the respondent number 2. In that context, Mr. Decker submitted that he wants to take fresh steps as the notice was issued in the year 2024. In view of this, the appellant is hereby directed to take fresh steps to the respondent number 2 to speech unusual. Within 2 days, let the matter be accordingly listed along with criminal appeal number 385 of 2025. On 28, you are saying it will may help also you also. If it takes a fresh step, then if it returns after service, then it will help. Yes. $43. No, hearing matter means one thing is there are some orders matters. Okay, it will be over 43. Let's see. I'm rising by 345. It may not. 11th of June. It's a Tuesday, Wednesday, Thursday. What is it? It is a Thursday. It's request made by for the sorry, appellant. Date matter be accordingly listed for hearing on 11/6/2010. It's 35 filing number 1. Why it is I is there? For DRI, as per your information, is there any counsel and case? No. You are for the respondent otherwise. Today to they have not appeared. Then appears a for DRI. So from the last order, it is seen that DRI sought for some time to make arrangement for engagement of new counsel to represent the DRI. Today, no one appeared for DRI. Third MS A day. You are A day. Huh? You Nanda. Third MS U Nanda appearing on here. You're appearing for behalf of Mr. SC Biswas. SC Biswas for the respond number 1. Let the matter be accordingly listed. After 2 weeks, after 2 weeks as on a date you take. Yes, what is 36 and 37? In 36, service for the respondent number 4. Mr. B. Is the matter without SK Sharma হবলে SK so you are representing whom? 5. So 4 is awaited till. Who is 4 in fact? Staff reporter. And how it will be reported now, how it will be served now, not known, name not known. Subsequently you got the details. Now how it will serve? Now you are you at a position to find out his the person or the name? Then how the service will be completed? Assamia proceeding. Yes, if you can, Mr. Kamar, if you can help. Assamia proceeding is otherwise attempt respondent number 1. Achha. 1, 2, 3. Yes, if you can identify the person. No, no, obviously complain. We are just asking, can you identify the name? Then how can we expect whom no, cannot expect the service also? Just think of it. If it is, yes, it is there. You are appearing for 5. Achha. No, now the question is that you think it. If 4 can be find out, it's okay. I'm saying. And suppose 4 in any case, but 4 is the necessary party, I think. Because he is the staff reporter. And that's what, and he is the necessary, you cannot delete his name also. Try to find it out and what to do otherwise. Otherwise it will be evaded. Okay, then. Heard Mr. S. Bought the learned counsel for the petitioner. Sorry, please. Heard Mr. S. Bought the learned senior advocate assisted by R. Sensua, the learned counsel for the petition. Also heard Mr. Chet Kamal, the learned senior counsel assisted by UR assistant B. D. Chaudhary for the respond number 1, 2, and 3. And heard MS. You are R, no? R. Purva for the respond number 5. From the office note reveals that the service is still awaited for the respond number 4. Most of let the service be awaited till next date of listing. When then you're saying what to do? When it can be listed? 2 weeks, 3 weeks? No, yes. After 2 weeks? You want any date fixed or what? Date fixed. Date fixed that maybe preferably on June, yes. 15th of June. The listing it on 15th of June. This is your 15th, you think? 15th of June. And what is 37? 37, you are for the petitioner. Okay, interim order be continued till next date. And what is 37? Acha. Okay. With the sound now for the here for the respondent, anyone is appearing? Oh, sole respondent. Oh, acha. Acha. Then we'll do one thing. We'll not put it or in the order because it's not confirmed news. So let not that be put on record. Yes, yes. No, what I am saying, no need. I think that should not be because if he is suppose he is for the God's sake, if he is alive, then it may be. We'll listing it along with so and so. Okay, personal capacity, we are listing it together with that one. No, if is suppose is there, any unfortunate thing is there, then you can just normal order will pass. Heard Mr. Chetkama, the learned senior counsel, assisted by Mr. Yes. B.D. Chaudhary, the learned counsel for the petitions, and also heard MS R. Purva, the learned counsel, appearing for the sole respondent number. List the matter along with criminal petition 1348 of 2025 on 15/6/2026. Interim be continued till next. We are not mention anything. If it is there in, suppose in that case, we just file it on the next date. Yes, interim will continue. 30 days supposed to file an affidavit. Affidavit by whom? Affidavit by you. Oh, acha. No, you have filed this petition for cancellation. Or you file it. No, not you. Acha, you file. Acha, bail cancellation filed by you. And what is IA for? Certain documents. Then can it be allowed? Then that's okay. That's what I'm saying. If suppose your petition is allowed today, then you can bring your thing to an additional affidavit in the main case. That will do. Or then what will do? Then you're praying for submission of some documents to bring on record. Cases filed by them, I can understand. How that is the confusing part. That's what I'm saying. What I'm saying, have you filed any objection there? Just you can file an objection or affidavit, and we are going to allow this one, so that the things which you want to bring in the record through an additional affidavit along with your written objection, it can be filed in the main case. We can produce this one. Otherwise, IA affidavit, there's no problem. Yes. Dismiss your petition. This IA, to this IA. Oh, but this IA is only for additional affidavit. IA code balance. Yes, yes, 191. Yes, 191. Yes. Prayer to night near. Prayer portion, na? Prayer portion. Oh, sorry. एक मिनट, हाँ. You cannot make such prayer through an is. We'll record your submission here, and you allow I will allow your. You can bring. I do खाली withdraw करा दियो. Mr. Amit, litigant counsel for the applicant, not Mr. PGM, litigant senior counsel assisted by D. Gogol. D. Gogol for the response. It is submitted by Mr. Amit that due to some technical irregularity, he wants to withdraw this prayer allowed. The I is accordingly disposed of. It one of them will be. At Mr. DJ Mohammed, the senior advocate, assisted by Mr. D. Gogol, the learned counsel for the petition, also had Mr. B. Sharma, the learned Mr. A. The learned counsel representing responsible. It is submitted by Mr. Ahmed that he wants to file some, he wants to bring some documents on record to an additional affidavit and publish. Accordingly, he may be accorded with next, considering this submission made by Mr. Ahmed, he is allowed to the no, when till when you want to submit your by matter may not be possible to list on Monday. Oh, acha, CD we have received CD, no? Mr. Sharma Dilane PP submitted that CD is received and it needs to be updated. In view of this, let the matter be listed. 27 is holiday. We're listing it on 26th of May. If you can, then we can list. We are going to list. 29, we are listing list numbers. 29, we are not going to list the list. First only 1/6. List the matter on 1/6/2026, enabling the respondent number 2 to file their written objection along with the affidavit to bring some documents on record. Further, the learned additional PP is also hereby asked to take necessary steps in calling the updated case diary, returning the same, which has been returning the CD which has received. 1/6 pardon. Yes, it is closed on withdrawal, and we are allowing to return objection along with the additional affidavit to bring you to bring on record some
39.
cancellation. Oh yes, one correction was there, na. Actually, it was my out of sight. It has gone. Just 2 PSC Gilder. Yes, yes, yes. Obviously. এইটো কোনে মাৰিছিলে গম পাই নেকি? একেটা মাৰি দিব পাৰিলে বেছি ভাল। কাৰেকশ্যনটো কোনে কৰিছিল মানে এইটো বেল অৰ্ডাৰ কোনে মাৰিছিল? আপুনি মাৰি দিব, এটা বেল অৰ্ডাৰ আছে, চিম্পল এটা কাৰেকশ্যন কৰি লাগে। মই লাইন নাম্বাৰটো আপোনাক কৈ দি আছোঁ। You are Mr. P. Dole. Heard Mr. P. Dole, the Learned Counsel appearing for the applicant. Also heard Mr. A. Busher, the Learned Additional PP, appearing on behalf of state respondent. That is an application for modification of the correction of the order dated 4/5/2026, passed in AP case number 894/2026, submitted by Mr. Dole that the said order inadvertently, it had in line number, which line? In para 3, in para 3, in third line, it had mentioned as inverted comma below river, 2 persons fell into the river bed for sudden failure of hydraulic check. It invert comma to a pop up which ought to have been written as 2 PSC girders, GIRDERS, girders fell into river bed for sudden failure of hydraulic check. ATF. Considering it is very learned edition, there is no objection for the prayer of correction. Accordingly, the order it is so is correction. Okay, it will be.
Regarding
Now, what is the stage? What? They have not appeared. You do one thing, Mr. Bhattakur. Really, I have some problem and 345. Mm. Oh. No, in the last occasion, scan copy of the teacher was called for in connection with Gitanagar PS registered and so and so. Acha, but your as per your information, charge sheet number is 09. Then what is your instruction? What is your information? Because prior to that filing of the charge sheet, you have not received any case diary. There may not be 209, maybe another number also. I don't know if you have some instructions regarding. But how, if it is proper number should be there, then only you can take instruction. Take instructions from all these regard as to whether charge sheet, we are not in a position to send one report is there. Obviously, it was your submission from the side that 209 was there. Yes. 23. Yes. Okay, then heard Mr. S. Potter, the learned counsel for the learned senior advocate, assisted by R. Sensua, the learned counsel for the petition, and also heard Mr. K. Busho, the learned additional PP, appearing on behalf of state respondent. But otherwise, we have received this scan copy here or not received? No. Oh, sorry, not received. Scan this here is not yet received. Reminder may be issued. Post hoc registry will do the need. However, it is submitted by Mr. Bortaku that as per information received from the additional PP, matter was inquired in regards to filing of the charge sheet number 209 of 2023, dated 30/11/2023, but it was not found in the concerned record. In view of this, the learned additional PP is hereby asked to take necessary instructions in regards to filing of the charge sheet in connection with the present case, and also and the matter may also be awaited for TCR. We are awaiting for TCR in the meantime. Pardon. As a copy of the order may also be accompanied along with the notice. 9th of June, yes, is the matter according to 9th. 2022 matter already. What had happened, we don't know. Okay, 9th. Next Tuesday, Thursday. Now, May we are already full. Not possible. Let it be on first week of June on a hearing day. 2nd of June is a Tuesday, that can be listed. At the request. Let the matter be listed for hearing on 2nd. We are listing it on 2nd. Yes, 44. You are for the as an amicus. Are it's a POXO. So they have one I is also there. Under which section POXO? POXO which section? Non-application call from the vacant appellate. Heard Mr. D.K. Bakshi, the learned amicus, appearing for the respondent number 2. And Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. Due to absence of the learned counsel for the appellant, matter will be list the matter according 10. We are listing it on 4th of June. It is a hearing day. Pardon? We'll try, because that's why we are fixing